Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Robert J. Morris, Jr., Chief Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning and welcome to the Second District Court of Appeal. This is our remote oral argument session. It's been a while since I've done one of these. All of mine have been live lately, so I may be a little bit rusty. I'll understand if you struggle with the technology also. I'll call the cases in the order listed on the docket. And when each case is called, there'll be a brief pause as you're transitioned into our virtual courtroom. After each case is completed, the participants are asked to leave the meeting, but may continue to view online if they wish. As a reminder, each side is given 20 minutes for argument. If you are the appellant, please let me know if you would like to reserve time for rebuttal. You may reserve up to 5 minutes, but no more than that. Please unmute your microphone when you're recognized to present your argument. Thank you. We are ready to proceed. Our first case is Alexander Walkin versus the State of Florida. Okay, Mr. Kendall, I think it's up to you.
Good morning, and may it please the court, counsel. My name is Anthony Kendall, and I represent Alexander Walkin in this appeal. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Okay.
Okay. As this panel is well aware, there's only so much time for oral argument, so I'm going to focus on 3 different areas of this of the argument. One would be the plea process under Rule 3.180 and the forms that were used. The second is what I call the impromptu motion to withdraw plea, in which Mr. Walkin was summoned before the court, and then the actual filed motion to withdraw plea. Not abandoning the other arguments. I'll rely on the briefs for that, but I think that these arguments are the ones that I can do. I can help the court with and trying to understand a little better. So, with that, on May 18th of 2021, Mr. Walkin entered a plea. It was negotiated. Now, interestingly enough, in the appellee's answer brief, the appellee did not respond to any of the 3.180 arguments about the defendant's presence. So I want to talk about those because this is a pretty big deal, actually.
Well, let me ask you a question about that, Mr. Candela, because I read your arguments and I was, I think we've, as a judicial branch, have expected some of these arguments in the post-pandemic era, where changes were made and rules were suspended about physical presence as opposed to video presence. So pretty much the Supreme Court suspended its own rule because of COVID to facilitate the ongoing judicial process that needed to go on and couldn't stop because of the pandemic. The system is too big, the cases are too many. People have a right to a speedy and expeditious resolution of their cases. Are you suggesting the Supreme Court didn't have the power to do that?
No, not at all, Your Honor.
Okay.
What I am suggesting is there was already procedures in place. This court in Jimenez, Mansfield and Scott cases had already decided this kind of issue. Video pleas are acceptable. They can be done as long as the appellant and their attorney are in the same place. And that's been the rule in this state for quite a while. Between this
didn't occur here, but there were at least 3 telephone calls that I recall that when your client said, I need to speak to my lawyer, he was able to do so by telephone. So that you're saying that's not sufficient?
That's not sufficient, Your Honor. Under the circumstances of this case, the fact of the matter is that the attorney and the defendant should be in the same place. A phone call, while can transmit information, it's not the same as when your attorney's right there and you can look and see, and hey, what does that mean? Or can you explain that to me better? The way that's set up, and I don't know that this would be going outside the record kind of, is there's a room at the Falkenberg Road jail that they do these videos in, and there's a bunch of chairs with a podium where the defendant or the appellant stands to do the plea, and then if he's got to call his attorney, he's got to go to the back of the room. There's other people in there. It's not this isn't a private.
But he's on a telephone, and Mr. Candela, the entire world is doing this now. They're just, I mean, the majority of meetings that I have and hearings that the court has are all done this way now. So, I mean, they're very rarely are we all in the same room together anymore.
Well, Your Honor, I understand that, but we have rules of procedure for a reason. And if we're not going to follow them, what's the point of having criminal rules?
Mr. Candela, the argument here is that this is an error. The question is, what type of error are you asserting it is? Is this a fundamental structural error, you know, that we've looked at over the years where, like, for example, the jury, is this an error where you have to establish prejudice? You have made it an assertion that not being in the same place is some sort of error. And, you know, we have to figure out and analyze what type of error it is. And if it's a structural error, that's one thing. And if it's a fundamental error, how we do it tells us what rules we followed. Just because the rule was violated, we have to still identify the nature of the error.
Correct, Your Honor. And I would say that this is a structural error, because there's a second part to this. So let's just say that the presence wasn't the issue. There's
So if
also
it's a structural error, you don't have to establish prejudice in fact. Is that correct?
Correct. However, if we had to establish prejudice in fact, there's a second prong to this, which would be that the defendant has to waive this procedure in writing, and we don't have that either. We have, if you go back to these to the plea forms and the forms, which are at record 99 through record 109, none of these forms are signed by the defendant. They're signed by his attorney.
But was there any objection at the time?
Mr.
Or
Walkin,
was there an acquiescence to the phone calls?
well, I think Mr. Walkin was relying on his attorney to provide him with information. I don't know that the attorney recognized that anything was wrong with this procedure.
So neither the attorney objected nor did the defendant complain.
Yes, that is correct, Your Honor.
Okay, so is it waived?
No, because it was raised in the motion for new trial, and that's a procedural mechanism in which you can raise an error involving the voluntariness of the plea. So that would be the vehicle by which we get to hear this matter. But as you know, this court's already ruled twice before that if the defendant puts it in writing and the attorney's with the defendant, that they can do these video pleas. It's not that hard. Plus, they can set them up where they can go into breakout rooms. I don't know why they don't do that. I know that you, Judge Morris, you said that you're in these meetings all the time. I'm sure that they can divide you out and put you in a special room to talk to whoever, and then come back as a group. That wasn't done here. And I'm not saying that's the end all be all, but the second part of it is the defendant has to do this. These forms that they're using, these plea forms, there is no case in Florida that's actually addressed who's got to sign these things. And in my argument, this would be no different than if an attorney drafted a will for somebody and then signed, hey, I'm signing for John Smith. I'm going to sign his rights away, or I'm going to sign and sign off. That would be absurd. It's the same thing with these plea forms. The procedure became so expedient to try to address the problem that no one stopped to say, hey, wait a second. Yes, the Supreme Court has suspended speedy trial. It didn't suspend all the rules. It suspended speedy trial, and it suspended some of the timeframes for adjusting things. But I was not aware of any administrative order from the Florida Supreme Court that suspended presence. And I think that as there was at least 4 cases in the state, 2 out of the 4th and 2 out of the 2nd, that address how this should happen. So there was already a framework there for all of the circuits, including the 13th, to follow.
Let me ask you a quick question. You're referring to a plea form and you're saying it needs to be signed. Is that correct?
Signed by the defendant.
Yes. So that's your contention. Is there a specific rule or statute that you're referring to other than an administrative order, or that's the way it's done?
There is no statute that I'm aware of, Your Honor. There is no
Okay.
rule that I'm aware of.
Well, in Daniel Webster's day, defendants would walk in the court, change their plea, you have a verbal change of plea, you might have a court reporter there, and that was the end of it. With the advent of paranoia, they invented these plea forms and say, you got to sign the plea forms, just to avoid someone contending after the fact that they weren't informed of what the sentence is going to be and other things. So if there's no requirement by rule or statute, and they didn't enforce it in this case, I'm trying to find out what is the prejudice unless he's saying there's an enumerated right he wasn't advised of.
When I'm talking about the forms, I'm talking about all the forms, but specifically, if you want to talk about the plea form, I think you're right, Your Honor. There is no rule. He didn't complain about it, but the problem becomes if the attorney can sign everything. In this case, the plea form, this waiver of physical presence in court form, and that if the court's going to construe that as a waiver, that's not the defendant. For instance, a stipulation in court as to evidence in a trial has to be signed by the defendant. If a defendant wants a non-jury trial, has to sign himself. The attorney can't sign for him.
Well,
Well, the non-jury trial is a personal right under the defendant's autonomy, whether we look at it under Fulminante or McCoy. So only the defendant can waive the right to a trial by jury, just like waiving the other rights to enter a plea. Those are personal matter of autonomous. So I see a difference there, because in this case, if he had a waiver, he confirmed almost all of the waivers when the judge did the discussion with the defendant. Is that your signature? Is that this? Is that that? He confirmed them all. So if I'm looking at Fulminante or if I'm looking at McCoy and those things that talk about a structural error, I don't see a structural error. It might be differently if only we had the signed stuff of the defendant by counsel, but we have more than that. So I think we moved out of structural into where he has to establish some sort of harmful error to get relief. And I may be wrong. There's 2 other judges on this panel, so don't rely on me.
Your Honor, if it is a fundamental error, then if that's going to be the case, then
If it's a structural error, then that's a failure of the process. You know, the 6th Amendment gives you certain rights, other constitutional rights. We have a line of cases from Arizona versus Fulminante, all the way to a recitation in the McCoy case about whether or not it was ineffective counsel. And the Supreme Court said, no, that's the right of autonomy. And I think your argument might be stronger if the defendant hadn't testified to the trial judge that that was indeed my signature, that I did agree to that, and I did these, rather than as compared to the defense lawyer signing everything and saying, hey, my client did this. That's all I'm saying right now with that narrow slice.
And I don't disagree with that, Your Honor. I think that with the plea colloquy that was done in this case, there was some confusion, and that's why we had 3 phone calls back and forth, and eventually the Mr. Walkin was able to make it through the plea colloquy. I don't want to get rid of. I think
I wasn't intending to take you off your 3 points and say, I think we're pretty clear on that last one.
The second one I want to talk about is the impromptu motion to withdraw plea, where no motions filed, nothing is brought before the court except for somehow the attorneys tell the judge that there's a problem, and Mr. Walkin is summoned back before the court. He's in custody, so it's not like he's free to disregard. He gets called in and they start this back and forth about whether or not he wants to move to withdraw his plea or not. Now, there's a lot of misinformation in there. The defense attorney says, hey, I told him 60 days. That's not the rule. Rule 3.170L requires 30 days, similar to the time frame to enter an appeal.
Does
I don't
that
know
matter
what
though? I mean, does that, I mean, he was within the 30 days anyway. I mean, so does that matter? The misinformation about the days?
It doesn't, because he didn't go outside it, but I do point it out because there was misinformation. There was also
The transcript is extremely interesting to read. There's a lot of confusion going on. I mean, I had to read it several times to get sense of it myself, as I did with the whole plea process. This was a very messy process, no question about that. But my question to you is, yes, that first impromptu dragging him into court and putting him on the spot like that, wasn't that cured by the later filing of a written motion that was denied?
Yes, but which brings me to the second point. In the first motion, he hadn't established anything, and the judge on two occasions, possibly three occasions, the way you read it, was granting the motion.
Yeah.
He then
That's
comes
true.
in on a written motion and it's denied. The manifest injustice isn't there. So I don't know how.
But he got a second bite at the apple without the judge striking the second motion as being, redundant and superfluous. I mean, he got a second free shot with a written motion.
Well, I don't know if it's a free shot, Your Honor. He had to go back and he had to go back through the process. Manifest injustice is a very strange concept. It's not like reasonable doubt. It's not like preponderance of the evidence. The closest I've ever come to understanding it is a case out of the Fifth that talks about Vega. It's kind of amorphous what has to be shown, and I think that the fact that he was brought back into court on that impromptu and the court was ready to court granted it. The oral pronouncement, if we had cut it right there, the oral pronouncement would have controlled. But that's not, that's not where we are. So the second motion was to, not a second bite at the apple, but to follow up on the incomplete hearing, I guess. And at that point, it was denied for not meeting the manifest injustice standard, which kind of seems crazy because the first time around, without anything, the judge was going to withdraw the plea, which means that he had to have met the standard.
But she later ultimately denied it. As confusing as that whole hearing was, you're right. It sounded like she was going to grant it 2 or 3 times, and then she ultimately denied it. So, but manifest injustice, according to the rule, it must be obviously unfair, shocking to the conscience, unfairness, which is direct, obvious, and observable, and that mere allegations are not enough. The defendant must offer proof of manifest injustice. So it's the proof part that I'm struggling with. And just so you know, you're at 16 minutes and 20 seconds. So you got less than a minute left if you want to preserve your rebuttal time.
Yes, I do want to preserve my rebuttal time. If I may take it now, and Your Honor.
Okay. All right. So you'll have 3 minutes when you come back. Okay. All right, Mr. Hellickson, it's your turn.
Good morning, Your Honors, and may it please the court. My name is James Hellickson. I represent the state of Florida, the appellee in this case. Just a quick thing, I want to point out that as far as presence goes, I would argue that we are all physically present for this virtual proceeding. We are complying with the rule. We can see and be seen. We can hear and be heard. You can question me. I can hear you. So in all actuality, this is about as close as an approximation as you're going to get to a physical court appearance. Now, going to the plea, and you have a record of it, was freely and voluntarily.
Well, let me go back to that, Mr. Hellickson. I mean, there is a requirement that he has a right to be present in the court. And while this is as close as you can get, it ain't. Right? So tell me why that's okay.
Well, Your Honor, it's okay because under the Well, one, since the Florida Supreme Court did indicate that if you could interpret the rule in a way that allowed, or that could be not favoring video, you were supposed to interpret it in a way that allowed the video, because they were trying to, again, keep the judicial system moving in the pandemic. And so they had to strike a balance between.
Well, we know all that.
Right.
Okay? But this is a critical stage in a very serious criminal proceeding. And the right to counsel, as we know, is sacrosanct in our system. And the right to confer with counsel is sacrosanct. And you heard Mr. Candela talk about the fact that while he may have been on the phone, he had no privacy on the phone. So his ability to confer with his lawyer in private was certainly abridged here. So is that a manifest injustice?
It's not, Your Honor.
Well,
And
it sure sounds like it ought to be.
But it's not, Your Honor, and here's why. Because there's a couple of things going on. First, the Zoom proceedings have never been held to be unconstitutional. And second, if you look at a plea proceeding, you want to make sure that the defendant knows what rights he has so he can voluntarily waive them. That's the purpose of the plea. So you're looking at the rights, and then you're looking at did he make a knowing and voluntarily waiver of the rights? And in this case, you have that, Your Honor. You have a record of the plea proceeding. You can look at and see if it was knowingly, voluntarily entered, and did he have the right? Did he have all the rights that he was entitled to? And in this case, he did. He had the right to talk to counsel as many times as he wished. He had the right to, if he wanted to stop the proceeding and ask a question, he could. So his right to counsel was not impeded. Was it not necessarily the things that we're used to in an in-person proceeding? Of course, nothing was the same under COVID, but we had.
Would you agree that this is definitely not a textbook plea that was taken?
Of course, Your Honor, that it wasn't. And if you
It's a
look
mess,
at,
isn't it? I mean, it's a mess. I mean, it's about as bad a plea as you can take. The question is it bad enough to undo it? You know, one of the things that bothers me is that he was asked if he'd given his attorney the right to sign the plea form and other forms for him. He said, no, I didn't give her the right. He didn't remember a lot of things were on the form. He asked the judge to read it. The judge said it's 4 pages long. I'm not reading that. You know, all that's not good.
well, it's not necessarily good, but the question is does it amount to a structural error? Does it amount to something that allows him to withdraw his plea? And the answer to that question is no. Because if you look at, and I know it goes back a ways, but if you look at the Florida Supreme Court's decision in Warren v. State, it goes back to 1995, and I understand that there were some different things there. But if you look at the plea there, and the Florida Supreme Court specifically says this is not a model, but the Florida Supreme Court also said that it did not amount to the prejudice standard under Rule 3.172 as I at the time. It's now 3.172J that required an automatic vacator of the plea. And so that's what you're looking at in these standards is does it require automatic vacator? And that's the answer to that question is no. And I know there was some discussion about if this is a structural defect or not, and it's not a structural defect. And if you look at the entire proceeding, he had what he was entitled to. And he made a knowingly involuntary waiver of his rights and entered the plea.
Mr. Hellickson, let me approach it from a slightly different matter and with an understanding that recently the Supreme Court of Florida changed the rules as they apply to Rule 3.850. Mr. Candela points out that counsel for the accused, in this case the appellant, got the days wrong. There's record transcripts that I read too, and I'm sure the panel did, where they were saying, where counsel says, I don't represent him anymore. I've been discharged without an order of discharge. There's a number of other things about, I don't have to file a notice of appeal. I'm looking at whether or not there's been, under the Sixth Amendment, the totality of all these various things render ineffective assistance of counsel. Where can we get to it now? I suspect not, but are we delaying the inevitable?
Well, I don't know if I can answer that, Your Honor, because
It hasn't been briefed, I don't think, so maybe it hasn't been preserved for a review, right?
Well, what I was going to say first is, Your Honor, is that, that particular Rule 3.850 obviously is going to be a different type of context that you're evaluating. and then on a direct appeal. And so I don't know that you're necessarily going to be asking the same questions.
If you're asking for the proper Sixth Amendment representation of counsel to ensure that the rights are protected under the Sixth Amendment, including the autonomous right to waive a trial by jury, waive the right to confrontation, and enter a plea, if the trial lawyer has not advised as to a particular collateral consequence, if trial counsel doesn't know the time of 60 days versus 30 days, if counsel is saying inappropriately, I don't represent them any longer, if counsel is saying, I don't have to put in a notice of appeal, and I think there's a Supreme Court opinion that said, you might have to. I'm wondering, is that something we need to look at under the new Supreme Court of Florida opinion, or would you urge us to wait until the record is, better developed under a standard 3850 motion? I'm concerned about a lot of what took place here as I read the transcript.
And Your Honor, I would argue that those particular questions, you probably want to wait for the record to be developed a little bit, because on the particular facts here and the particular arguments here, is it was focused on the voluntariness and the plea proceeding as a whole. So I think that meshing a Rule 3.850 claim in there, I don't want to say you can't do it. Obviously, you're concerned about the Sixth Amendment. You might be able to raise it on the face of the record if that's where you're kind of thinking.
Well, it has to be a fundamental error now, doesn't it? Isn't that what the Supreme Court said? Because they changed the rules, I think, earlier about raising 3850 on a direct appeal, and that's what this is, as distinguished from before. And they said only if it can be established that it's some sort of fundamental error. I think they raised the bar on it, and I may have the wrong words, and I apologize if I do.
Oh, it's okay, Your Honor. I would argue that under the kind of the case law that's been developed as far as pleas go, this is probably not going to get you there. And I say that with respect to this is if you look at I know it's a little bit of a cross-reference.
Maybe it's Judge Moore's point. He may have cured everything under his colloquy with the judge. Yeah, I understand it now, and yeah, I did do it now. And arguably, the collateral consequence may not be a directed thing under 3850 as part of the plea. So there's a whole lot of, but I'm just looking at the total package. And as Judge Moore said, I had a little concern with what the trial judge was doing, and I had a concern about what the defense lawyer was doing. I don't know how they merge, but it creates a concern.
Well, Your Honor, what I would point out too is if you look at a couple different cases, and it's kind of, I think it's related to where you're going with this. If you look at Major, which says that the companion requirement of Rule 3.172C is Rule 11C of the federal rules. And then if you look at a couple cases that out of the United States Supreme Court that deal with Federal Rule of Criminal Procedure 11C, they've come out and said you do not automatically vacate a plea unless you can, like you were talking about under the Rule 3.850 standard, unless you can show that it affects, those substantial rights. There is no automatic vacator under the federal rules. You apply two sets of rules depending on if there's an objection. If there is an objection, you'd apply the traditional harmless error standard. If there's not an objection under the federal rules, you would apply plain error. And that's under the United States. They came out with two separate cases, United States v. Vaughn, and then later United States v. Davila, D-A-V-I-L-A. And the Davila court specifically mentioned that we did not want to get into these automatic vacator of the plea. And they also went so far as to say these plea errors are not structural. They said that they said that here, and it's on it's 569 US 597 at 611, where the court says we have characterized as structural a very limited class of errors that trigger automatic reversal because they undermine the fairness of a criminal proceeding as a whole. They go on to explain those, and they say Rule 11 C1 error does not belong in that highly exceptional category. And then they say structural errors are fundamental constitutional errors that defy analysis by harmless error standards. And the court, and if you look at the concurring opinion in Davila, with Justice Scalia and Thomas concurring, they say, I agree with the court that a defendant must be prejudiced by a Rule 11C error to obtain relief. That is because the text of Federal Rule of Criminal Procedure 11H says exactly that, in words whose meaning is crystal clear. Harmless error. A variance from the requirements of this rule is harmless if the error does not affect substantial rights. As the court recognizes, this rule calls for an across-the-board application of the harmless error prescription or absent prompt objection, the plainless error rule. And so I think that, as you pointed out, Judge Casanova, that you are kind of mixing that 3.850 standard here, but I think under the court's precedent, you have to get to that fundamental error standard to be able to consider it even under the new rule. And I know they're a little bit disjointed there with the federal rules and the Florida rules, but I think they're, similar in that they both address the pleas. And I think that, you have to get that high standard to, one, say it's an automatic vacator. The United States Supreme Court said these plea errors, we don't think that they're structural under Rule 11, Federal Rule of Criminal Procedure 11C1. So my argument there is that, that the companion rule is Florida Rule of Criminal Procedure 3.172. That's also not the structural error. So I would, say that under your analysis, looking at a 3.850, you'd also have to hit that high bar to say this needs to be a fundamental error standard, unless you want.
You'd have to bring it somehow within the protections afforded by the Sixth Amendment. And at this time, I'm not certain there's any clarity that would suggest that that's the case. I just want to be sure that I was traveling down the right road with both counsel here, give them a chance to make sure that I'd heard. I don't want to take up all your time here on that one.
Oh, no, Your Honor. Another case that kind of came out as far as the Zoom proceedings was, it's out of the Massachusetts Supreme Court, but it's Vasquez-Diaz, and they kind of do a good job of going through all these different analysis as far as the Zoom proceedings. And one of the things that they did talk about was that it does not impede the right to counsel. I know under our plea proceeding here, you had the phone calls where under here, we can do breakout rooms and things like that. I'm not so sure that wouldn't rise to that level of an automatic vacator just because you have a phone call versus a breakout. But the court did go through a lot of the analysis that you're talking about, and they said that this does not violate that Sixth Amendment right or confrontation, because Zoom essentially gives you the approximate of an in-person hearing. And just briefly, Your Honor, as far as that second plea hearing goes, that was not as problematic because the plea was left in place. The trial court did not on its own vacate the plea. So the plea he had when he entered it was the plea he had going into that second hearing. His answers to the trial court about whether he wanted to withdraw his plea were equivocal. So the trial court there did the proper thing and left the plea in place. And then when he filed his motion to formally withdraw it, that one was properly denied as well. So I don't know if Your Honors have any further questions. I'd be happy to entertain them. If not, I would just argue that the entire plea proceeding was constitutional. There is a record of what occurred, and the state would rest on its brief.
Thank you, sir. Mr. Candela, you have 3 minutes.
Just a couple of points of clarity. The federal rules regarding withdrawal, those are addressed under in the Supreme Court cases are addressed solely under the federal rules. We're talking more about a Sixth Amendment, 14th Amendment incorporation type of argument when you're dealing with the states. So I think those are, while that may be illustrative of some of the principles, I don't know that that's the end all be all of how that, bless you, Your Honor, of how that should be. Some of the other issues that you hit upon, yes, a defense attorney, once there's a plea, has a requirement under Rule 9.140D to remain active unless there's good cause, and a written motion, which there was neither in this case, cannot be removed because they may have to file a notice of appeal and the documents. And you were the case that you were looking for is Garza v. Idaho. Judge Casanova, that's the one where if the Supreme Court said, even if there's an appeal waiver, if the defense attorney doesn't file the notice of appeal, that is ineffective assistance of counsel under the Sixth Amendment. Misadvice.
But my concern with that one is we would need an evidentiary hearing to hear counsel say whether or not they had a waiver in their folder, whether they've spoken to counsel, and that's the distinct. And I think that's one of the reasons why the Supreme Court raised the bar on cases like this on the direct appeal, wanting to have a full record on other issues before the courts would grant a 3850 motion. And this may be illustrative of that need.
And that may be, Your Honor. The main case out of Florida, out of the misadvice in terms of a plea, that's the LaRue case, Florida Supreme Court, that if that influenced it, but that's again a 3850 issue.
Yeah.
That's
We're
not-
only dealing here with the Sixth Amendment fundamental thing, something that will jump right out that we can say is wrong. As I pointed out, I'm concerned about it, but I don't know that that this court can address it right yet. If there is anything to address, that's assuming. So don't take up all 3 of your minutes.
No. And then the other two, just for clarification, is that 60 days comes out of the modification rule 3.800C. And that's not the same as the 3.17L, which is the motion to withdraw plea after sentencing, which is much more stringent than the withdraw plea before sentencing. So at this point, Your Honors, I would argue that this plea process was flawed, structurally flawed. And I would ask that the lower court, or that this court reverse the lower court on that matter, and grant the motion to withdraw the plea, or in the alternative, deal with this process and clarify it such that this issue doesn't come up before. If this court is to remand, we would ask to be remanded to a different judge, just because of what transpired in that second hearing just doesn't seem right. But anyways, that's my argument.
Thank you both. You did an excellent job. This is an interesting case with a lot of interesting issues, and you both did an excellent job briefing it and arguing it, and we thank you for that. Have a good day.
Thank you, Your Honor.
Our next case is AJ Therapy Center versus Imperial Fire and Casualty Insurance Company. Okay, Mr. Barr, I think you're up, but we have an unusual procedural wrinkle in this case, right?
Yes, we do, Judge.
So the appellant has confessed error, which leaves us in a strange posture because we don't have a final order from a trial court, so we don't have jurisdiction to hear this case. You want to respond to that first?
Yeah, we've had a very difficult time with this particular trial judge trying to get this order signed. I've reached out multiple times. I think our motion for extension, list all the efforts we have made to try and get this order. And as recently as, I believe, Friday, I reached out to the judge again, to the JA, and was basically said the order is under advisement. So I honestly didn't know whether I should file a writ of mandamus or what I should do to get the trial judge to move on this issue.
Well, if there's a confession of error, I mean, one of the trial judge's options, they seem pretty, they don't seem like there's a whole lot of options, are there?
Well, no, I agree with that. But my argument in response to the confession of error was that the court should disregard the confession of error and enter an opinion, and let's wait till we get a final order, because we need this court to adopt the rulings of the Fifth and the 14th.
Well, you may need all that, but we have a confession of error, which means we don't have a final order. We don't have jurisdiction to do any of the things that you want us to do. We just don't have jurisdiction. And when you don't have jurisdiction, you can't act. And you guys can't stipulate to jurisdiction, as you know. We all learned pretty early in civil procedure in law school. I'm not sure we can do anything here today.
I tend to agree with you. I was a little bit surprised that we kept the oral argument on. I know it's your time is valuable.
No one asked to cancel oral arguments, so we did not take it upon ourselves unilaterally to do that without hearing from you all first, in case there was something that we needed to hear about. I understand the order went out to grant you an extension of time. I think we can probably wait for that period of time to see if the trial judge grants us an order, but I think as Judge Morris points out, what do we do after that 30 days is over and the trial judge is still deliberating? Does that leave you with as you point out, a writ of mandamus to compel a ruling?
I think arguably it does. And I think we have to cross that bridge once we get there. Hopefully, I know I will keep reaching out to the JA to see what the status is. I know that I feel like in the last email I was becoming a bit bothersome to them. So I want to make sure that I'm doing things the right way.
Yeah, they're still struggling with that COVID backlog, as you know, but
Yeah.
still you need them to respond to you. So,
Right.
yeah, don't give up. Be patient, but be
Understood.
forceful as you can.
Understood. I don't have any other.
Yeah, I don't know what else to say either. This is kind of, this doesn't come up much. You know? And I'm sorry we can't be productive and do anything today. We're obviously all geared up. We've read the case. But for the confession of judgment, I'm sure we're ready to hear what you had to say, a conference a case and make a ruling, but we can't. So.
Well, I will continue to make efforts to get that ruling entered and be diligent in that regard.
Okay. Have a good
Let
day,
us assume
gentlemen.
hypothetically you get the order timely. Then you would send us notice of it. There would be no need to reschedule. We could presume, I think we could proceed then as an OAW, so to speak, and then resolve it on the briefing and the confession of error.
Yes, again, my argument would be that I would just be to request the court to actually enter an opinion, notwithstanding the concession of error.
Well, I think I understand that. I don't know that we'd be giving the trial judge any guidance if we say we accepted the confession of error and not tell the trial judge what the error was. So I agree with you there. Mr. Middlebark, are you okay with that as well? And if I apologize if I mispronounced.
No, you pronounced it correctly, and may it please the court, I agree with everything that's being planned.
Okay.
And Judge Casanova, I just want to say I apologize. I didn't think to even file a motion to cancel OA. I assumed the court would have done that, so that was my error.
No, there's no problem. It doesn't change our salary to hear this at all. So we're glad to do it and to see you all here and make sure that we haven't missed anything. This isn't, as you counsel have quite well pointed, this is kind of an interesting thing because the orders that you were attached from below, some did what this judge did, another sit on summary judgment and did it on judgment on the pleadings, and we'll leave it there. I just don't want to leave you all in the lurch either. As Judge Morris has said, without a final order, we're kind of stuck, and writing an opinion with dicta is not a favored thing to do.
All right, well, I will continue to get on getting the order done.
Okay.
All right.
Thank you, gentlemen. Have a good day.
Thank you.
For your time.
Our next case is Weyland Corporation versus Venetian Multifamily, LLC. Okay, Mr. Higgins, I think you're up, sir.
Morning. May it please the court, counsel. My name is Hugh Higgins, and I am counsel for Weyland Corporation, the petitioner in this matter. Weyland filed the petition for writ of certiorari to quash the trial court's order, which prohibited production of internal emails sent by the
Mr. Higgins, you're going to reserve rebuttal time? I'm sorry to interrupt, but.
Yes, please. 3 minutes. Thank you.
3
Your Honor.
minutes? Okay, go ahead, sir.
Thank you. This petition is due to the court prohibiting production of Venetian internal emails sent by employees of the developer entity.
How many emails are we talking about? Because I sort of lost track. Initially, it was 200 and there was lots of documents involved, but I feel like it got down to a pretty small number, didn't it?
Yes, Your Honor. Initially, it was hundreds. Through the amended privilege log process, Venetian voluntarily turned hundreds over. And Weyland agreed to not seek a lot of emails if there was outside counsel on it. So we're down to a group of less than 50 documents at this point.
Okay.
And at appendix pages 60 through 78, there's a document titled Exhibit C to our
And
petition.
they argued that these emails had to do with strategy conversations about their contract and if they took certain positions on it. And they asserted a privilege on that basis, as best I understand it.
The gist.
Go ahead, sir.
Yes, the gist is that Venetian is arguing that these were prepared in anticipation of litigation and incorrectly states that the first emails Weyland is seeking are in the summer of 2017. There are actually some emails that are highlighted in blue that are in the October and November 2016 timeframe. And the contract was signed in October of 2016. So to think that there was anticipation of litigation all the way back in that timeframe, it just mind boggles Weyland.
But the trial court judge did an in-camera inspection and basically sustained their objection on this very limited batch of emails. You're here on a writ of cert, so you got to prove that the trial court departed from the essential requirements of the law. And it seems to me the trial court made a judgment call based on this in-camera inspection. So they did the inspection. It's hard to see a departure from the law. They did the inspection, they looked at the emails, they made a call, and that's an abuse of discretion standard, isn't it?
It would be an abuse.
Okay, so you got to show they departed from the essential requirements of law, which means it's not just legal error, it's got to be egregious, serious legal error. And this is an abuse of discretion standard, looking at emails of less than 50 and a huge batch of documents have been explained, and you've argued that is a departure from the essential requirements of the law. Why don't you focus on that first? How can, it doesn't seem like that can be.
Yes, Your Honor. First, there's only two categories of documents that Weyland is seeking on appeal. First, there are documents that Venetian claims are duplicates of documents presumably previously produced in litigation, but for some reason doesn't agree to produce them now. We're at a loss as to why any duplicates of previously produced documents wouldn't simply be turned over at this point.
You've argued they've waived the privilege by virtue of that, right?
Right. To the extent a document was previously produced and is now being withheld as duplicate, that's waived. It should be produced. If there's some other situation, then we can address that. It wasn't made clear in the order. The order found documents were duplicative, documents were not relevant, and documents were privileged. And there was no explanation as to which were duplicative, which were irrelevant, and which were actually privileged.
So the court, in sustaining their objections, didn't make it clear it was doing it on privilege?
It did not. There was multiple conjunctions used. So the wording of the order is that if the court finds that those plaintiff has claimed to be duplicative in nature and/or previously produced as a result of chain emails are as such, period. Further, any objections asserted to the documents in their entirety based upon privilege or relevance is with merit and are hereby sustained. This is found at appendix page.
Well, your basic complaint is the court doesn't give a rationale for its holding, a specific rationale, correct? We don't know why the judge did exactly what she did, except for the vagueness of the order. So
that's one of the issues, yes.
And if you had questions as to why, Judge, what are you doing here and why, giving specifics, were you required to file a motion for rehearing? And if you did, what happened?
We don't believe we were required to file a motion for rehearing. We didn't. We sought a timely appeal.
Okay, so you're filing a timely appeal based upon the order that might have been clarified, might not have. So you take the order the way it is, and you expect us to be clairvoyant to say the judge had improper motives. You know, the order on appeal is presumed to be correct. So we have a duty to sustain the trial, judge, unless you carry your burden to show error. So what is the error with a vague order? Do we defer to the judge? There's no requirement the judge give a better order than she did, that I know of. It's just a vague order. And when it's vague, it
just
goes
to
to
be
the
clear,
judge's benefit.
To be clear, that's not our only position.
No, I understand that, but keep going. Give me some more.
Right, so withholding of documents based on relevance grounds, as we've pointed out in the brief, is an improper basis. We haven't seen the email, so we can't possibly understand how an email about the Venetian project generated during the Venetian project could be irrelevant to the case when this construction case has literally issues coming out of the seams. But that was one of the grounds for not producing emails. The Giacalone case makes clear that relevance is not the be all end all. If it's likely to lead to the discovery of admissible evidence, it shouldn't be prohibited. And there's no way to cure the impact that withholding a potentially important document could have on the fact finder's ultimate decision in the case. We'll never know which document actually would have tipped the scales because we don't have access to it. We don't have the ability to develop further information on it. And the concept that there could be work product generated in the same month as the contract was executed, even though Venetian contends.
I heard you say that the first time, and I mean, at the time the contract's executed, they probably had legal counsel talking to them about the contract, probably had them involved in the preparation of the contract, or at least consulting with them. And I can imagine emails that basically said, you got this provision, this is what's going to happen if that doesn't work out. I can see them getting legal advice at that stage of potential litigation. Everybody knows these big construction projects frequently lead to litigation. I mean, that's not a big surprise. So I'm not necessarily going to say that there's no way they would have had some privileged conversations on the front end at the execution. I mean, I could actually see more likely that there would be.
And keep in mind, Your Honor, these are communications that are internal to the Venetian team only. We've excluded from our request any communications that went to outside legal counsel.
Well,
These are just
even so, I can still see them having these conversations on the front end. I mean, these big, complicated construction projects are fraught with controversy. I think, you obviously do this kind of work. You know what I'm saying is true.
They certainly do end up in litigation frequently. I won't deny that. The manner in which hundreds of emails were withheld through a vague privilege log and then eventually giving more information. Initially, they were labeled as, quote, attorney work product, and then it was changed to simply work product. Weyland has a particularly difficult time with this adversary changing the terms of.
Well, show us how this court abused its discretion in basically viewing these less than 50 emails as, not to be disclosed.
If
Be
these
specific
emails,
about that. Yeah, I mean, how did the court abuse its discretion in exercising the decision not to order the production of these less than 50 emails, which is what we're talking about here?
if the internal emails are not work product privileged.
Well, how
and
do you
they've
know
been-
that?
I don't have the benefit of knowing that.
Well, that's the thing. I mean, it'd be one thing if the court didn't conduct an in-camera inspection and said, hey, I'm not going to make them produce them. But the court did conduct an in-camera inspection and made a judgment call, which is subject to an abuse of discretion standard. And all you can do is theorize that the court made a ruling that they were privileged when in fact they weren't. You don't know that. We don't know that. Right?
Based on how we've been shielded from the actual information, I can't disagree with that, Your Honor.
Okay.
We can
So-
only say that,
I mean, that just creates a problem for you because the search standard is so high and so difficult to meet. You got to show it's a departure from the essential requirements of the law. And you've pretty much told me yourself, you're really not able to do that. You think that might have happened, but you don't know that.
we just can't imagine a circumstance where Venetian was already contemplating suing Weyland after signing the contract or in the month following. That we would hope for better than that.
Yeah.
Well, counsel, let me follow up a question that Judge Volante argued about showing. In preparing for today's oral argument, there's a recent, I think it is a 5th District case involving public supermarkets versus Molina, came out in April. And there is a passage in there that says irreparable harm is jurisdictional and must be found before a court may even consider whether there has been a departure from the essential requirements of law. And here's where it kind of triggers what Judge Volante said. Only if the petition demonstrates clearly that the appellate court has jurisdiction by virtue of irreparable harm not correctable on plenary appeal will the court move on to the question of whether there's a departure. And as you pointed out in response to your questions, you haven't seen them. There's no non-disclosure orders or something. So how do you meet that standard of showing us that there's been a clear departure? I mean, a jurisdictional thing here before you move on to a clear departure. My concern is that, this may have to wait for plenary appeal.
And perhaps the court needs to have the benefit of being able to review the documents in camera to be able to make that assessment, because we don't have the benefit of
Well, the trial court here did it, and had the trial court not done an in-camera inspection, may have changed the procedure, because there's cases that exist where the trial court fails to do that and cert is granted. But this is a denial from cert, and those are a little bit more difficult to get here in terms of certiorari, as Judge Morse is pointing out in the opening. And I thought that passage kind of illuminates, or at least places a context for our analysis here. Now granted, rehearing is not over in that case, according to my photocopy that I printed up here, but it did, kind of put things forward.
And in the Molina case, in fairness, that dealt with discovery requests to a third party, the actual financial bias discovery of a healthcare provider. So that was in the realm of being more of a side issue, as opposed to here we're dealing with communications prepared by the plaintiff.
So your argument is that this brings you within the language of that passage about clearly demonstrable for jurisdiction purposes. Irreparable harm must be found before a court may even consider whether there's been a departure. And so you're saying that you have demonstrated that we have jurisdiction because the harm is not correctable on appeal when we don't even know what they are? I'm kind of concerned that in the lack of what we have, as Judge Volante was exploring for purposes of cert, and the nature of the relief being not automatic, has it left you in a very difficult position to establish the jurisdictional requirements, whereas perhaps on a direct appeal, you can ask the court to put it under seal, or you can see to make your argument of what it might lead to or other things. We don't know what it is either, so it kind of impacts us as well, doesn't it?
Procedurally, yes. And I in the ideal circumstances, the court would have before it the records have been withheld to be able to analyze whether there was abuse of discretion. So if the court,
I appreciate you dealing with me, because as I've told the other judges, I always have a unique problem when I'm dealing with cert, because I want to treat it as a direct appeal and get to the merits. Maybe it's my days as an old trial judge. Let's solve the problem. But I have to give due deference to what the appellate law says about jurisdiction, and that's why I wanted to get your take on this.
and if the court has the power to compel those documents for purposes of the petition review, then that would enable the court to assess its jurisdictional position.
Thank you for bearing with me. I'll let you get back to your argument. I know you've only got 3 minutes reserved and I don't want to take up all of this. one.
Yeah, you've got 1 minute of your time that you didn't reserve. So you're at 16 minutes right now.
Okay. I'll defer the remainder of my time to rebuttal. Thank you.
Well, you only, okay, that's fine. You'll get 4 minutes then, okay?
Thank you.
All right. Ms. Swain, it's your turn. Good
Thank you, Your
morning.
Honors. Good morning. May it please the court and counsel. I am counsel Morgan Swing. I'm counsel for the plaintiff, Venetian Multifamily LLC, which I'll be referring to as Venetian. Given the questions that Your Honor have asked, I can first state that I agree wholeheartedly that in this case, the court did hold a hearing, did have an inspection, and made a decision after an in-camera review, and agreed that this case and these documents, which were very limited, and I'll get to in a moment.
So Ms. Swing, does that mean in this posture, the case that this, in other cases in the same posture as this case, that we could never grant cert when a court has done an in-camera review and decided whether documents come in or don't come in? So we can never second guess that?
No, and I would say that there are a couple of cases that have been cited in this case, the Gia Cologne case and the Bourne case, neither of which apply in this particular instance. In those cases, there would be the possibility for granting cert. In those cases, I'm not sure an in-camera inspection had occurred, but there are specific instances in which there would be no ability for the other side to be able to obtain documents that they need, either in the Bourne case to even get standing in the case, which they couldn't get, and that's why they were seeking those documents, or when there was no ability to go through specific set of healthcare requirements to show in the Gia Cologne case, and I may be mispronouncing it, I apologize, which is a second DCA case. There were specific requirements that to show the pricing problems with the hospital, and they needed those documents to be able to show it. So that might be an instance in which cert would be available, but that's not here in this case because—
Well, I'm troubled by this court's order that it basically is, prohibiting the disclosure of these documents based on the fact that they might have already been given, things like that. That's troublesome. I mean, I understand the privilege part. I can even understand the relevance, but on the basis that they've previously been given in a sea of documents, which is, it's not even fair to put that on opposing counsel, try to figure, okay, which in the sea of documents are these less than 50 are we talking about? I'm troubled by that.
And I can address that issue very briefly. What happened here, and I can explain the court's order right here, is this is very clear in the transcript that was set forth of that April 13th hearing. I was the one who argued the hearing. Mr. Higgins was not. His co-counsel, or actually his colleague, was the one who argued it. There were, of the many privilege log entries, there were many entries which were duplicative. That has become really a question, and then I think maybe there was a misunderstanding of what went on. And I will explain. This duplicative nature falls into two specific categories. Weyland is seeking documents here that consist of email chains. And so, which was set forth in the argument to the court, many of these email chains were duplicative, meaning one, certain email chains included both work product privileged and non-privileged documents. So for example, maybe the bottom email was not privileged and had been previously produced to Weyland. But then the two emails on top of that in the chain were work product. Perhaps Weyland had sent an email to Venetian, and then Venetian internally had a discussion about that email. So the duplicative nature, or the documents that were already produced, were the document on the bottom, and the first email was produced. Either that whole email chain with the two top ones redacted, or it had been produced in a separate email. And then the two top ones were the work product. So there were no documents that were privileged, that we're asserting the privilege on, that were otherwise produced. That's the issue where the court says, the court, having conducted an in-camera inspection and review of the documents, finds that those Venetian had claimed to be duplicative in nature and or previously produced as a result of email chains are such. So in the argument on April 13, I was the one who made the argument. I explained to the court that, one, some of these email chains of the 54 documents on the privilege log that were in blue that Weyland was looking for, some of those emails first were actually duplicative of one another. Meaning, again, if you had an email chain, let's say there are 3 emails, one of the items on the log would be an email chain that had 2 of those emails. Then another one on the log would be that same email chain, but would have 3 emails. So that's the duplicative nature. So meaning of those 54 emails, you might have 4 of those 54, entries. You might have 3 of those that would be the same email chain. That's duplicative nature. I explained that to the judge. And in the April 15th letter, which we included in our appendix, I went through in painstaking detail to show the court and made notations for the court to show which portions were privileged, which portions had already been produced, which were the non-privileged portion, and which ones were duplicative of one another, and that's set forth in the letter. So in fact, no documents that were privileged were actually produced.
So that it leaves one question for me. The order that ultimately gets signed, is that something that the judge self-produced or the parties had a say as to this is the order that we would provide, or how did that come about? Because it's a horribly vague order. I can see why it's confusing to the other side.
This was produced, this order was written by the judge herself after, I believe she received these documents. I sent them on the 15th. She received them by that Monday. And then she submitted this order, I think, the next day. So what she says, and she refers, I think, to the argument, and we have the transcript that says that she conducted the in-camera inspection and finds that those documents that Venetian has claimed to be duplicative in nature and are previously produced as a result of email chains are as such. To, I think, alleviate any concerns through her in-camera inspection that Weyland may have, that no privilege that when Venetian made the proffer to the court that certain documents were duplicative or certain documents were, a portion of them had been produced and were not privileged. And by the way, I noted on the document for her to show this is the Bates stamp number where that portion that was not privileged was previously produced. She's letting everyone know, yes, Venetian's proffer and statement in front of the open court is true. There's no other issue. So I think reading this order in conjunction with the transcript is helpful. Then she goes on to say, further, any objections asserted to the documents. So now we've set aside the duplicative, now we've set aside the privilege, just looking at the work product privilege documents, those objections asserted to the documents in their entirety based upon privilege or relevance is with merit and are hereby sustained. So you have to read them in separate issues. Really, there was that one issue going on to clarify any confusion, and she's saying, yes, we agree with the plaintiff in that instance, Venetian, and yes, now I've taken a look at the remainder of these documents, they are privileged, and we sustain the objection.
All right, thank you.
Okay. I'd like to quickly address something that Mr. Higgins had noted. He noted that, and this goes to the issue of actually finding up a privilege. He noted that there were many documents that came from the 2016 timeframe. And in fact, if you look at my letter, and you correspond, and I did this before, and I did this again, in preparation for this hearing, each one of these particular entries, the 54, which Weyland specifically was told by the judge that they needed to provide to counsel for the plaintiff of the particular entries with which they still took issue, for the plaintiff to produce those documents to the court. Plaintiff went through, provided those documents. Each one of those documents are documents from 2017, particularly starting around June 2017, right up and leading up to that period of mediation and the second addendum that is mentioned that occurred between the parties. And then afterwards, in 2018, after all of these issues about the scope of work, about the work product, about the type of work that was going on, the change orders and everything that's all part and parcel of as Mr. Higgins put it, the issues coming out of the seams in this case, that's when everything started. So there are in fact no documents from 2016 that are left in here. And so the back and forth of the production, the back and forth of the emails between the parties when they were setting forth and putting together the contract, those have not been withheld, but for any attorney-client privilege documents, which Mr. Higgins has agreed that Weyland would not seek to produce. So in fact, there are no 2016 documents. And so any arguments that Weyland would make, saying that they would not be able to get and support their fraud and the inducement claim, I think would be improper, to follow up on Your Honor's questioning. Once again, I do agree with Your Honor that there is a significant issue that Mr. Higgins needs to address with respect to the essential requirements of the law. And he has not met that departure because, again, this trial court has lived with this case from the inception. This is a case that's been going on for more than 3 years, has been set for trial, has almost gone to trial 3 times. We're on the 4th amended complaint. This is a situation in which Weyland has.
Is this relevant to the issue on appeal? I mean, I really don't want to hear the
Just to
background.
show that the trial. That's fine, Your Honor. I offer the background, but if it's not required,
Nobody asked.
I think the worry is we just want you to stay within the record.
That's fine, Your
Honor.
I'll go back to just briefly, as Mr. Higgins hasn't been able to touch on it yet. Each one of the arguments that that Weyland has made in their brief and their petition, we believe fall flat. As I've gone through the duplicates issue. I don't think that there was we don't believe that there was any waiver, as I've discussed in more detail. Again, Weyland makes a relevance argument. Relevance here is irrelevant if a document is privileged. And so relevance in and of itself is not going to cause an issue. Weyland is seeking and trying to get the whole universe of the documents. And I think it's very clear from the pleadings and also Mr. Higgins' argument that they're trying and they're scrambling to be able to try to find any particular documents, and they're unable to do so. It sounds like you don't have any questions on the privilege. I'm happy to discuss it, but can move forward if there are no issues or questions about the issue of whether or not there would be a privilege.
No questions from me.
Okay. I'll touch very briefly on the other issue about waiver. Weyland raises an issue about bad faith conduct and seeking an entire waiver. Again, as we've addressed in our papers, and I can rely mostly on our papers, this is an issue that's actually outside of the scope for this court, as these issues are not actually even part of the motion to overrule or for in-camera inspection. This is an issue that was part of a motion for sanctions that was previously held in front of the trial court. The trial court denied it, and it is not even part of the particular relief that is sought by Weyland on this particular narrow issue. And so we think that that issue, among other reasons, is improper, but certainly is not before the jurisdiction of this court. Once again, following up on Weyland's need for documents outweighs the privilege, I think that that issue is part and parcel of one of the questions you asked me before, in that, is there any circumstance in which the court could, grant a cert petition? And I discussed that there are circumstances, but they don't fall in this particular case, because all the cases that have been cited in this case relate to specific instances where the party who was looking for discovery could point to a specific item that they needed, be it a specific inspection report, specific information from a particular witness. Here, it appears to be that Weyland is looking simply for the universe of documents and is almost fishing for more documents and trying to eviscerate the work product privilege. And so, in fact, we believe that the harm to Venetian would be greater by allowing the slippery slope and allowing work product privilege to be produced without such a significant showing. Thank you, Your Honors.
Thank you. Mr. Higgins, you have 4 minutes.
Thank you. I'll be very brief on rebuttal. I have 3 points. The first of which is Weyland is being asked to operate on trust. I've listened to the explanation, but the end of the story is Weyland is being asked to trust the process without knowing whether these documents are privileged, without knowing whether these documents don't meet the production standard on relevance. Second point is that
Doesn't that happen all in any in-camera inspection?
And it does, and in some cases, an in-camera inspection occurs, the court gets it wrong, and a petition for writ is filed, as happened in the Boren case, which is 243 Southern Third 448. In that case, the court granted a motion for protective order precluding production. It was challenged, and the DCA stated that the court failed to make a finding of good cause and provided no explanation in its order as to why the protective order was granted to the scope that it was. And so we're asking for the same relief, even though an in-camera inspection was conducted. We're sitting on an order that doesn't provide a showing of good cause. And the last point that I have is that at appendix page 77, line items 842, 843, and 844, these are all part of the highlighted set that we produced to council in advance of the hearing. These documents have not been produced, and they're dated October 21st, 2016, October 21st, 2016, and November 4th, 2016, respectively. So without question, documents in the 2016 timeframe have been withheld. We're seeking those in addition to the others that we've requested, and we thank the court very much for its time.
Okay. Thank you both. These cert discovery cases are always challenging and difficult. You both did a nice job in your briefs, and your oral arguments were very helpful to us. So thank you. Have a good day.
Thank you.
Thank you.
Sir, the last case, one of the attorneys is not here yet.
Okay.
So Lombardo is, but Mr. Fink is not. Might be a good time for a short break.
All right, let's take a 10-minute break. We'll be back at 11:06. No. Yeah, no, 10:56. We'll be back at 10:56. I think we're back. So let's take our next case. Is Mr. Fink here?
Yes, sir, he is.
Okay, great. So we're ready to go then. Our next case is Davila versus Bollard. And I apologize if I did not pronounce those names correctly. Okay, Mr. Lombardo, you're up, sir.
Thank you, Your Honor. Your Honor, as it may please the court, I'm Chris Lombardo here on behalf of the appellant. I'm with co-counsel Zach Lombardo, my son. Your Honor, this appeal comes from an order the trial court entered with regard to a motion for contempt.
Mr. Lombardo, before you get into it, are you going to reserve rebuttal time?
Yes. Thank you. I'd like to reserve 5 minutes. I
Okay.
appreciate that.
Yes, sir. Thank you.
What this essentially is an issue of a parenting plan. We have parties that entered into a parenting plan back in 2018, which was then entered into a supplemental final judgment as well in February 2018. It is a shared parenting responsibility parenting plan. But like many shared parenting plans, we have certain decisions the parties made jointly that were memorialized in that parenting plan. For instance, who pays for the health insurance or the holiday schedules, or how we're going to handle extracurricular activities. We also provided in paragraph 5.8 a provision for how we're going to determine where these children go to school.
And there's no question that the agreement says that the former wife's residence will determine the school zone.
Correct.
Question really in this case is, does that mean she controls where the children go to school? Because as we know in this case, she endeavored to move to Collier County and wanted to put the children in school in Collier County in the zone of her new residence, right?
Correct. Well, initially what she wanted to do was put them into a private school in Colorado.
Right.
And then later, and so
And she was told no.
Right.
Told no by the court. She couldn't do that.
Well, what she was told was, we're going to maintain the status quo until we can hear the former husband's supplemental petition for modification. And she was given the opportunity to file a counter supplemental petition. And ultimately, we did try the supplemental petition, which the former husband lost. And part of the issue here is there's no geographic restriction beyond 6113001, the 50-mile radius. So given the 50-mile radius, the mother could have moved to DeSoto County, Sarasota County, Hendry County, Glades County, Charlotte County, Collier County, and within the Lee County district. Had they wanted something tighter than that, they could have negotiated that. Had they wanted a provision that it would be the Cape Coral charter schools, they could have put that in the parenting plan. It is not. And so what we have is a parenting plan that says we've made the decision that mom's address controls the schools and the school district choice. So she moved within 50 miles. That's undisputed. She's in North Naples within the 50. In fact, she's within 40 miles. And what we have is a circumstance where the trial court ultimately looked at the supplemental petition for modification, which was amended, by the way, after the original hearing from the magistrate with regard to the August of 2019 order. In February of 2020, the former husband and the father amends his supplemental petition, and he asks for increased time sharing, modify child support, modify the decision-making authority, give him ultimate decision authority, modify the parenting plan to restrict the children to Cape Coral charter schools, modify the school designation to his address, and then add a relocation restriction. That case,
so the agreement itself then doesn't really provide for shared parenting responsibility?
Oh, no, it does provide for shared.
Well, if it does, then shouldn't there have been a shared decision on the change of schools?
Well, there actually was, because in the parenting plan itself, the parties made the decision that mom's address is the controlling address. Now, I would agree that if she said, I want private school or homeschooling or virtual schooling, that is a decision that was not made and needed to be addressed. But if they wanted something more restrictive, and look, what you'll see is when we try the case.
Well, if I'm a textualist, I read that argument to say that that provision says that the zone at the time the contract was entered is where the children go to school.
Well, that's not how I read it.
Well,
what it's-
again, if I'm a pure textualist, that's how it would be read, right?
Well, I'm not so sure I agree with that. If you're a pure textualist, what it says is mom's address shall be used for school designation. It does not say, and this is the school, which it could have. They could have provided for all of that. They didn't. And when you look at the cases that the court relied on at the time of the trial, and in particular, Hutchinson and Regal, both of them shared parental responsibility circumstances. So both of them, we have the same approach. And both of them, the court concluded that within the 50-mile radius, because there was no greater geographic restriction.
I understand your argument, but isn't that all kind of moot once you have the general magistrate make a report and recommendation that the mother doesn't object to the findings of fact, doesn't file for rehearing? Didn't the magistrate resolve all of these issues?
No, he did not. What he did was he entered an order of enforcement for purposes. It was a request filed simultaneously with supplemental petition. It was a request for a temporary injunction to maintain the status quo. What the court said was granted. And then the court gave her the opportunity to file a counter petition. And then the court actually tried the case subsequently, which is how you wind up with the ultimate decision in this case, which finds that the former husband did not meet his obligation. And when you look at that, and what you realize is the court did not amend its parenting plan. The parenting plan, as we sit here today.
You're begging the question that it needed to be amended. The argument, I think the magistrate said it's clear, it's evident, and Judge Carlin said she's in contempt. She violated the court order. She took the kids unilaterally out of school. That was never part of the program here. You're saying, oh, her address controls over everything else, and the judge didn't buy that.
No, that's
that argument.
That's not exactly what I'm saying. What I'm saying is these parties made a decision that her address controls school designation. I would agree that when it comes to private school or other types of school or education, that does not control.
Why? Why just that? Why do you limit your argument to that point? Why do you tie your hands? Why isn't it good for everything?
Because obviously, if there is a switch to say homeschooling, that to me is a different issue.
Okay, but you're being a judge and jury of that issue. That's why we have you have agreements, and the judge is the ultimate decider.
Well,
and
actually,
adopted the magistrate's report.
Well, so the way I see this is these parents are the ultimate deciders, and they've made their decision in that parenting plan. And what the court, when you look at the final order of the court, what you have is a restriction requiring the children to go to Cape Coral charter schools, which is nowhere in the parenting plan. It prohibits Cape Coral from unenrolling them, nowhere in the parenting plan. It prohibits the district school board of Collier County from enrolling them. Mind you, there are six other counties within the 50-mile zone. And so ultimately, when you look at the supplemental petition, the amended supplemental petition that the former husband filed, where the former husband asked for all that relief and it's denied. And the court essentially has said the parenting plan stands as it exists. So you cannot hold her first in contempt because there's not a clear statement, and certainly it isn't deliberate or willful when the court says the parenting plan stands. There was in the final order, there was no provision that saved or incorporated the prior order, which we believe was a temporary order. I mean, that order was done in anticipation of further judicial effort to resolve that issue. We tried the case, they lost. She won. She had the right to move. She still has the right to move within that 50-mile radius. And they made the decision that when it comes to school, it is based upon her address. And so this idea that now somehow we wind up with this much more restrictive provision, which cannot be done on a motion. I mean, we tried the supplemental petition, they lost.
Well,
and then they filed a motion, and now we have a parenting plan, presumably, that's been amended by a motion that limits the children to Cape Coral schools. Had she moved within Lee County, she could have done that. It would have been a change. There's nothing that would require it.
You're going really fast. Isn't the parenting plan required? Didn't the parenting plan require the parents to confer on all decisions regarding the children's best interest, including education? Isn't that in 2.3, parents to confer?
It's the standard language for shared parenting, and you're right, yes. But Just like other aspects, for instance, health insurance, the parties made that decision and reduced it to writing so the court would be clear with regard to school and school district choices, it would be mother's address. So otherwise what you're doing is saying those words.
Back in 2018.
Correct. And that's never been amended. And there was a specific request by the father in his amended supplemental petition to modify that and provide that it would be his address. That was denied.
Well,
so
obviously, the problem is it's reactive to an interpretation that nobody saw coming, and the judge didn't agree that she had the right to do what you say she had the clear right to do. And I understand what you're saying. She got in there, my address. If I move, it's still my address. And I don't think the husband bought that. He said, hey, the parenting plan trumps her physical address.
Well, and see, the parenting plan does provide for the school designation. I mean, that's the point. And it has to be in there, and they have to make that decision, and they made that decision. And so the court can't come back later and say, I interpret a designation of mom's address as not really being mom's address, because that's what's happening here.
Well, I don't want to bog you down with the same question, but if you have some other points, you can move on. I didn't mean to.
Well, that's okay. That is the primary issue here. I mean,
Okay.
I get this. And the point is, when you look at, for instance, what the trial court did at the trial, is the trial court concluded they did not meet their the standard of a substantial change in circumstances. And in fact, quoted Hutchinson and the Regal case, which is a move of less than 50 miles, including a change in schools, does not constitute a substantial change in circumstances. When you have a parenting plan that says mother's address or father's address, for that matter, is the address we're going to use, and it hasn't been changed, then that's what controls. Now, there may be other variations on the theme that may require additional input, and I agree, because not every decision was made. But when it comes to public schools, the address of mom was the controlling address. And so when you get to the point where you look at this and say, okay, so what did the court do? The court maintained the status quo until we had time to try it. And in fact, the father recognized that, because the father, after the court entered that order, amended his supplemental petition to add the additional relief. We tried that case, and the court decided that they did not meet their burden. So the parenting plan stands as written, which is mom's address. And that's important, because when it comes to, and particularly the language the court used, the court stated and relied upon the fact that the mere moving of less than 50 miles coupled with a change in school is not sufficient. And so when you take that and interpret that, the ruling of the court at the end of the trial that's in writing, from mom's perspective, the parenting plan doesn't change. The move was not a substantial change in circumstances. The change in school was not a substantial change in circumstances. So things remain the same. She has the right to move. So you cannot possibly hold her in contempt when that order did not incorporate the prior order. That prior order is no longer of any force and effect. That order was there to maintain the status quo until the case could be tried. We tried it, and the court concluded that they did not meet their burden. And so this is not a circumstance where one provision usurps the other. No, quite the contrary. It is a memorialization of a decision, no different than mom gets Christmas Eve on odd numbered years. That's a memorialization of a parenting decision they made jointly. They put it in writing, and it's there. And so that's what you have in this circumstance, is when it comes to school choice purposes, it's there. And so when you look at what the court ultimately did in its final order on the contempt, the court went way beyond what it could do, because we're now looking at a motion, not a petition. The court's already ruled that the supplemental petition failed. And then the court, despite what the court ruled with regard to the supplemental petition, turns right around in a motion for contempt and then provides the relief that was requested in the supplemental petition. And so, quite frankly, you can't do both. You can't say that the supplemental petition requests don't meet the standard and are not a substantial change in circumstances which would warrant a modification of the parenting plan, and then turn around on a motion for contempt and say, but we're going to amend the parenting plan. Because nowhere in the parenting plan does it say that these children are going to go to Cape Coral charter schools. It doesn't say it. Nowhere does it provide that the Cape Coral School District can't unenroll the children, or that the Collier School District can't enroll them. So you cannot take in a motion and do an amendment to the parenting plan. That's absolutely unequivocally the law in the state of Florida. Nor can you take a circumstance where you have now an amendment and then hold a person in contempt for what you've just amended. And so the prior interpretation, which literally just says granted, and you have to look then at the prayer for relief. And what was the prayer for relief? The prayer for relief was maintain the status quo. Why was it maintain the status quo? Because simultaneously they filed a supplemental petition for modification, which they subsequently amended. That's what we tried. And so when we get to the end of this, that parenting plan, even as we sit here right now, still says the exact same thing, that moms.
Lombardo, just so you know, you're under a rebuttal time, but it's your time. You can use it any way you
Oh,
want.
well, so from our perspective, this is a circumstance where this court needs to recognize that the trial court went way beyond its jurisdiction in amending a parenting plan on a motion, and it needs to be reversed. And we don't see this as a circumstance where the one is trumping the other. What we see is a written, just like in Regal, just like in Hutchinson, a written presentation of a parenting decision. And I thank you for your time.
Okay, you'll have 4.5 minutes when you return. Mr. Fink?
May it please the court, Your Honor. Your Honors, Mike Fink on behalf of Scott Carl Bollard. The August 27th, 2019 final order determined the issues that are raised today. Having said that, I want to tell the court how important this matter is. It's of great importance to the families of Florida, because Chapter 61, Section 61.13 2B3B requires in the parenting plan that they put in an address to be used for school boundary determination and registration. However, there is no framework or structure to determine which parent that would be. And what happens throughout Florida on a daily basis is these families are in mediation. They go, oh, and we need to put this, we need to designate who's going to be the designation for school boundary and determination registration. And the folks will say, oh, it's just for school bus or this sort of thing. And it's taken somewhat for granted, but it's essentially an arbitrary type of provision that has to be in there. And with all due respect, and Mr. Lombardo was not in the case and was not the lawyer who did not appeal the August 27, 2019 final order. But nonetheless, the appellant's position today, quite frankly, is inconsistent with the best interests of minor children, and certainly the principles of shared parenting, to the extent that, as far as we are concerned, on behalf of the father, and we think that, and on behalf of the minor children in Florida, that shared parenting is primary, and that to allow and permit this provision that is required to be placed in each parenting plan to essentially create a super parent who can move anywhere at any time, as many times as they want, less than 50 miles, take the kids out, put them in a new school over and over again. I mean, technically, that's what they're saying, without any input or review from the court or input.
Mr. Fink, the problem is that's the way the agreement seems to read. That's the tough part about it.
That is absolutely the tough part about it. There's no cases on
point blank that the children's school will be determined by the mother's address. And it doesn't say that if she's going to move, she's got to consult with the husband. It doesn't say any of those things.
Absolutely. That's why it's so important, because we've not been able to find any case.
But you're asking us to read language into this contract.
I'm asking the court find that the principles of shared parenting are omnipotent, that they are going to be involved in all significant decisions related to the minor children, no matter what the provisions say, at least in my opinion. And I know that our position is they don't get there, and you don't have, this should be a PCA. But if you're going to write anything, you should write something that supports and helps provide fundamental stability to the shared parenting principles, and that does not essentially set up what could be, and essentially in this case was a trap door.
Well, I think unfortunately, if we were to write, we would probably say that the lawyer should have included this language in this agreement to make it clear. I mean, it's unfortunate, but the agreement reads the way it reads. That's the tough part about this. There should have been more language to explain.
Right, absolutely. In any case I've handled since, I've made sure that I've placed something in there to override, to do what the law should be, what I believe the law is, frankly, by saying this provision is not going to determine, be dispositive. It's simply technical reasons, not to determine what school they go to.
Well, tell me about the special magistrate. Was there an evidentiary hearing?
There was, Your Honor. The court initially, as we indicated, entered the order August 27, 2019, resolved, as far as we are concerned, all the issues, and I don't frankly appreciate any real argument that would change the fact that that was a final order. Mr. Lombardo wasn't there. Nobody said this is, holding on, or that there was more to happen, other than I certainly wanted to make sure when I filed the supplemental petition that if there was going to be more concern about it, I'd rather change things to my client's benefit. It had nothing to do with the fact that that was an order that was appealable at the time, and it was waived and nobody appealed it. Again, it wasn't Mr. Lombardo's decision to make, and he wasn't involved in the case, but he also wasn't involved to be able to say what the appellant was told or not told and what things meant. The bottom line is, based on, we think it's clear under the Charles v. Williams case that this particular appeal by the contemptor trying to attack the underlying order is inappropriate and not permitted. So we don't see a technical appeal here because it was previously determined. This is the court previously made the same decision that it made a year or so before, that they did not appeal. So I do not believe there's any legal basis for the court to address their appeal. And while they've made some, they said that the appellee has attempted to classify the prior motion as a motion to enforce. That's a decision that was made by the magistrate at the time. And again, they decided not to appeal it, or at least an appeal did not take place. And so they are stuck with how the court, within its discretion, treated the father's motion related to the mother's attempt to unilaterally move the children out of schools and out of the schools they've been going to, and the school district they've been going to their whole lives. That classification is likewise, we believe, unassailable and not something that can be readdressed as a matter of law. We believe that the motion to enforce was proper, the contempt was proper. She was aware of the type of conduct and what would be violative of the order because of the August 27, 2019 order in the first place. So that when she did the same thing, she should reasonably expect that there would be contempt proceedings, and she can't basically say that she had.
Well, did she or did she not ask the father to approve her decision to move and change the school for the children before she did? And he said, no, I don't agree to that.
No, she made the decision before she approached the father. In fact,
And then he
filled out all the
found out.
application. Right, fill out all the applications and didn't put him on there, or
She didn't consult him at all.
apologize.
He wasn't consulted ahead of time.
No, Your Honor,
So in other words, beg forgiveness after the fact is what happened in this
that's
case.
correct.
Okay. Thank you.
So, we believe that the court should uphold the trial court's decision. The August 27th, 2019 order is dispositive. It was a final order. They did not appeal. We do believe that the issues presented are extremely important, that the shared parenting, the principles related to it, and really the legislature's focus and the history would suggest and certainly support how important it is for parents to cooperate and make major decisions, even in the light of 61.13 subsection 2B, 3B, which requires an address of one of the parents be designated as a boundary and determination for school and registration purposes. Again, if they were to disagree about it, and that's why it's like the last thing that is decided, what would be the structure? The statute doesn't provide any, legislature doesn't provide any guidance as to how that would be litigated. That would be a stumbling block to every parenting plan, and is now more than it ever has been. And there's no case directly on point. Thank you, Judge.
Thank you, sir. Mr. Lombardo, you have 4.5 minutes, sir.
Thank you, Your Honor. First, the August 27, 2019 order is clearly not a final order. It anticipates additional judicial effort, in fact, directs that. It grants, and you have to look at the prayer for relief, it grants a request to maintain the status quo until the trial. Who asked for the trial? The father asked for the trial. He filed a supplemental petition, an amended supplemental petition, and asked for this relief. That what is happening here is a confusion about shared parental responsibility. The reality is we have shared parental responsibility, but the parties have made certain decisions. For instance, holiday schedules. We would not say today that we have to come back and now come to a consensus again each holiday over who gets which holiday. No, they made the decision in writing. They could have, and the truth is, when we all recognize the rules, 61.13.001 provides 50-mile radius. They could have asked for less. They could have provided for a specific school. The request is for an address under the statute. That's not what they did. They said they went beyond. They said, no, we're going to use mom's address no matter what. Mom's address, mom's residence for purposes of school choice and school district. So the decision was made. What's important to recognize is on August 20th, 2020, the trial court entered an order that through the special magistrate after a full trial, and it said, based on the case law, neither the increased driving time or the change of schools meets the necessary criteria to establish the first prong of the modification test. The initial prong has not been met. The petition is denied.
Would it have made a difference if the word current was inserted before mom's address?
It would have. Words have meaning. You could have said current address. You could have said this address. They could have said Cape Coral Charter Schools. And Judge, you're correct. The reality is, as a practitioner, here's what we go through when we negotiate these. We talk about the issues. What's important? Is it important to you that these children are in a particular school district or in a particular charter school or a series of charter schools? Well, then you put it in the agreement because you don't want to wind up where we are right now. What we have is a circumstance where they made a decision, and what really the appellee is asking is for you to create confusion. We have a lot of case law that basically says what I've just said, which is just the move and a change of school is not sufficient. If you want something more than that, you either negotiate it up front, and lawyers beware, that's what you need to do, or you file a supplemental petition, and you better have enough to meet the first prong, which is a substantial change in circumstances. You have to ask yourself this: if the August 2019 order was final and resolved all the issues, as Mr. Pink has suggested, how in the world and why in the world did we have a trial on their supplemental petition? And why do we have a circumstance where the court says it's denied? And if you look at their amended supplemental petition, here's what you see: a request for all of that relief that the court then put in the 2021 order under a motion. That was denied. The reality is we have stability. We may have to warn our practitioners that you need to be aware of this. mean, I have done this for 40 years and I have done this in a variety of ways. We get it. It's a 50 mile. You can say Lee County schools only. You could say Cape Coral schools only. I mean, if that's what the parties decide, that's what they decide. If they decide dad's address, then sorry, mom, it's dad's address. And you may not always like that. And unless he crosses the 50-mile mark, you're not going to have a say. You gave up that right. You had counsel, you entered a written agreement, you did what you made the decision. You cannot now ask a trial court to add language to the agreement, which is exactly what's being requested. Where we want particular schools, we want a geographic location, we want to restrict school districts from rolling and unenrolling, who aren't even a party, and we want to hold a party in contempt when the court said the parenting plan stands as it is. So you can't get there. What the trial court did was a mistake. It was an error, and it needs to be reversed. This is not a situation where we're asking for a super parent, nor are we suggesting that somehow we're going to create instability. No, quite the contrary. Here is the warning.
Lombardo, you're out of time, sir.
Let me finish with this. The warning is this: the words have meaning. Negotiate your parenting plans carefully and recognize that courts cannot add language to the plan. Thank you.
Thank you both. This, of course, is a very tough issue in family law, and it's painful to watch children have to be victimized by these types of things, but it is what it is, and your briefs and your arguments were very helpful to us in understanding the issue, and I thank you for that.
Thank you, Your Honor. Thank you for doing this by Zoom.
This concludes our morning docket. We will retire to consider these cases. Thank you very much.
Good day.
Thank you.